Let's get started with our next session. So far, we have seen two chapters, that is nature of contracts, and then the other chapter is all about the consideration. Now we'll see the third chapter, that is other essential elements of a contract. If you remember, already in our unit 1, we have completed this topic called essentials of a contract. Like greater than 18 years of age, should be of sound mind, and should not be disqualified to enter into a contract. We'll learn the same essentials here, that is the capacity to contract. Under capacity to contract, we'll learn the same things but in detail. And again, pre-consent, we'll learn in detail. Lawful constitution and object, not expressly declared void. So all these essentials element of a valid contract we'll learn in detail. Already the basics were covered in there. We'll look what further description of this is there in our this chapter as in other essential. So this had already been discussed that an agreement results from a proposal by one party and acceptance by other. We have already discussed offer, acceptance and consideration in detail. We shall now discuss in detail the elements which constitute a valid contract in detail. So the parties must be, Section 10 of the Indian Contract Act provides, the parties must be competent to contract. It must be by the free consent of the parties. It must be made for a lawful consideration with a lawful object, and it should not have been expressly declared a void. These four essentials we learn in. So coming to the first, capacity to contract. They have given the meaning. Capacity refers to the competence of the parties, that is eligibility of the parties to make a contract. It is one of the essential elements to form a valid contract. Yes, capacity is one of the essential elements. Who is competent to contract is given by section 10. Okay, essentials are given by section 10 if you see above all this, but who is competent is given by section 11. Every person is competent to a contract who is of the age of majority according to the law to which he is subject to, and who is of sound mind and is not disqualified from contracting by any law which he is subject. Okay, just three simple points for the competency. The first point is age of majority, the second one is he should be of sound mind, and the third one is disqualified. Now we'll see in detail the analysis of this section 11. The section deals with personal capacity of three types of individuals. Every person is competent to contract who has attained age of majority, who is of sound mind and not disqualified. Again, the repetition. Age of majority, it said the majority according to the law to which he is subject to. We Indian citizens are subject to Indian Majority Act 1875. So, as per Indian Majority Act 1875, the age of majority is 18 years. Okay? Every person domiciled, that means the origin of that person is in India, shall attain the age of majority on the completion of 18 years of age and not before. The age of majority being 18 years, a person less than that age, even by a day, this is the key. In questions, they may say that he would be attaining 18 tomorrow, the very next day of the contract and all that. No, even if he is of less than by one day, he would be minor for the purpose of contracting. Okay, to confuse us, they would say all that he would be attaining within couple of hours and all that, but even by a day. Law relating to minors agreement, we'll see what is the position of a minor if in case he entered into a contract. So we should know that, right? If in case we enter into a contract with a minor and later on they say this, anyways it's a void, but what are the implications, we'll see. A contract made with or by a minor is void ab initio. That means void from the initial stage, void from beginning. In the leading case of Mohari Bibi versus Dharmo Das Ghosh, in this case, a minor borrowed 20,000 from B as a security for the same, executed a mortgage in his favor. Minor borrowed 20,000 and for this he gave a security. He mortgaged some property. He became a major a few months later and filed a suit for the declaration that the mortgage executed by him during his minority was void and should be cancelled. Yeah. So entering contract with minors itself void ab initio. Later on, he just went ahead and said, this security executed by me is not valid, that can be cancelled. Decision was definitely given in his case, though he said the security is, not valid because that was given at the time of my minority. Yes, decision is in his favor since that contract itself is void. he is not entitled to repayment of money and all that. Though we sue against him, decision would not be in our favor. It would be always in favor of minors, saying that he need not pay and we cannot enforce any security against him. So that is Mohari BB versus Dharmo Das Ghosh case law. Now, and it is especially provided in section 10 that a person who is competent to contract cannot make a contract within the meaning of the act. Yes. No ratification after retaining majority. Ratification means correction. Okay. A minor cannot ratify or correct the agreement on attaining majority. Maybe an agreement was entered in when he was minor, and later on if he comes and says, I want to correct that agreement and all that, that's not valid. Okay. Because the original agreement is itself void ab initio, and correcting or ratifying it later will not make it valid. A void agreement is a void agreement. A void agreement can never be ratified. Example, X a minor makes a promissory note in the name of Y. On attaining majority, he cannot ratify it, and if he makes a new promissory note in place of old one, here the new promissory note which he executed after attaining majority is also void, being without consideration. Okay, so this is very important. Okay, initially when he is a minor, he made a promissory note. Though after attaining majority, for the same contract, if he makes a new promissory note in the place of old one, even that is void, because an agreement with minor is always void ab initio. Now, minor can be a beneficiary or can take benefit out of a contract. What is this? We said any contract with is void and all that, but this should not prevent them from getting some benefits. Okay, because everyone would be like, would not enter into a contract and they would be losing all the benefits. So to safeguard them, there's a point minor can be a beneficiary or can take benefit of it out of a contract. Though a minor is not competent to contract, nothing in the contract act prevents him from making the other party bound to the minor. Okay, though he is not competent to contract, but law makes other party bound to him. Thus, a promissory note duly executed in favor of a minor is not void and can be sued upon by him. Okay, for example, what did we say? Promissory note executed by minor is void ab initio. Should understand this. Ab initio. But if the same promissory note is executed in favor of a minor for the benefit of the minor, if the same promissory note is executed, the other party is bound to that promissory note and minor can sue him. Okay, because he though incompetent, but if there is a benefit, he can accept that benefit. That's the essence. Remember, promissory note executed by minor is void ab initio. No one can file a case against a minor for their promissory. But if someone else, if others executed for the benefit of minor, okay, for the benefit of minor, then this minor, the other party is bound to this promissory note and this minor can sue against that. If someone doesn't, pay money against this promissory note and all that, minor can go to court and he can file a case. A minor cannot become a partner in a partnership firm. However, he may, with the consent of all the partners, be admitted to the benefits of the partner. So, partnership becoming a partner in partnership firm is again a contract, but contract with minor is void ab initio. So, he cannot be a partner, but then he can be admitted to the benefits. If you see, minor can be a beneficiary or can take benefit. Okay. A mortgage was executed in favor of a minor, held he can get a decree, the decree's decision for the enforcement of the mortgage. Court order, decrees court order. Executed in favor of minor, that is for the benefit of the minor, he can get that enforced. A minor can always plead minority. Plead minority is nothing but take advantage in this. He can say that I am a minor and court will be favorable to him. A minor can always plead minority and is not stopped to do so even when he has taken any loan or entered into a contract by falsely representing that he was injured. So see the intent of this, the kind of protection that is given. Though he entered into a contract by saying, by falsely representing that he was a major, still he can say, I'm a minor, I'm not valid for this. I mean, this contract is not enforceable. Rule of estoppel. Remember, we've seen estoppel, acknowledgement or estoppel. We understood estoppel is that it prevents person from saying, earlier he had made a statement. By giving this rule of estoppel, law prevents a person from changing that statement given by him. He cannot go back and change that statement. But against minor, though earlier he said that I am a major, rule of estoppel cannot be applied against a minor, so he can come back and change the statement again saying that no, I'm not a major, I'm a minor. The rule of estoppel cannot be applied against a minor. It means he can be allowed to plead his minority in defense. He can use that as a defense. Okay, minority can always plead minority. So we need to be really careful while entering into a contract to identify whether a person is minor or a major. Okay, so that's why we have to learn so much. Liability for necessary. Now, liability for necessary. What is this? Now that law has said contract with minor is void. So, understand the situation. A genuine minor is now prevented from entering into a contract, even if that is for his necessaries, that is required to lead his life. Even in that cases, no one is coming forward to enter into a contract. So that's where, for the benefit of them, law said liability for necessaries can be these sort of can be taken care of. We'll see. The case of necessaries supplied to a minor or to any other person whom such minor is legally bound to support is governed by section 68 of the Indian Contract Act. So the necessary supply to minor, not only minor, this section 68 of Indian Contract Act also covers any other person whom such minor is legally bound to support. Okay, maybe he's legally bound to support this, maybe his sister or brother or whoever he is legally bound to support. A claim for necessaries supplied to a minor is enforceable by law. Why did law come up with this? Necessaries is something maybe that maybe food, clothing, or basic necessaries. Now that law is so, I mean, partial towards minor, everyone is being afraid of entering into a contract. So law said, please do not take it that way. For necessaries, you can come and sue. That would be enforceable by law. Though contract with a minor is void ab initio, when the contract is for the necessaries, your contract will be enforceable by law. That's what law is saying. But a minor is not liable for any price that he may promise, and never for more than the value of the necessary. Okay, but he is not liable for any price. So because what happens? For a goods worth 50,000, they may promise 1 lakh. So that's again in this case, court of law is protecting minor. It's not that just because we said against necessaries contract are enforceable by law, it doesn't mean that for any price minor is liable. He is not liable more than the value of the necessary. Okay. There is no personal liability of the minor, only his property is liable. Again, saying that value of the necessaries, that means it's not that all his personal liability and everything will be to the extent he has got the property, that much can be. More than the property, we cannot give. To render minors estate liable for necessaries, two conditions must be satisfied. What are those two conditions? First of all, the law said for necessaries you can enter into a contract and that will be enforceable. For that, they said two conditions. The contract must be for the goods reasonably necessary. Reasonably necessary means it's food, clothing, all this kind of thing, and not that luxuries and all that. It should be reasonably necessary for his support in the station in life. The minor must not have already sufficient supply of already has got abundant food, clothing, and everything. I mean, the necessaries for his life. Or after, in spite of having all this, if a contract is entered, again, that's not enforceable. It should be the contract must be for the goods reasonably necessary, and he should not already have a sufficient supply of this necessary. Necessaries means those things that are essentially needed. They cannot include luxuries or costly or unnecessary articles. Okay. Necessaries extend to all such things as reasonable persons would supply to an infant in that class of society to which the infant belongs. Here the class of society is given. For example, an infant is a sports person. Okay. For a sports person, for this class of sports persons, normal food is not sufficient. They should be supplemented with proper proteins, vitamins, and all that. In that case, necessaries would be all this, not just normal food that would be given for children of his age. A sports minor would require more supplements. So we'll have to see based on this his situation, based on his status of life, what is necessary differs to person. Okay. Expenses on minors' education, on funeral ceremonies come within the scope of word necessary. Minors' education and funeral also comes within this. The whole question turns upon the minor status in life. That's what I said. Normal minor differs from a sports person or for whom the supplements or the food would be more demanding, and even clothing, or maybe a sports person would require good quality shoes and all that. So depending on the minor status, necessaries differ based to person on person. Utility rather than ornament the criterion. Utility, no ornament, no luxuries, and only utility criteria. That's how law says we can enter into necessaries, liability for necessaries enforced. If we say even liability for necessaries is not enforceable, then no one would come forward to provide necessary. That's the reason the point has come. Now, contract by guardian, how far enforceable? Some minors will have guardian, so we'll see how far their contract. Though a minor's agreement is void, his guardian can, under certain some circumstances, enter into a valid contract on minor's behalf. Again, we said contract with minors is void ab initio. So there might be some contracts which are necessary for that minor, and no one will come forward because we are saying void ab initio. So law is again giving a provision that contract by guardian is enforceable on minor's behalf, where the guardian makes a contract for the minor which is within his competence and which is for the benefit of the minor. That should be again guardian's competence also comes into picture. Guardian should be a major, and guardian should not be a person of unsound mind and all that. So that should be guardian's competence comes into picture, and it should be benefit of the minor. When a guardian is entering, these two points are there will be a valid contract under which the minor can enforce. But all contracts made by guardian on behalf of a minor are not valid. Again, guardians taking advantage of this clause, contract by guardian is enforceable. Again, some they might enter into contracts which are not beneficial. So that's the reason law says, for instance, the guardian of a minor has no power to bind the minor by a contract for the purchase of immovable property. He cannot just bind a minor for purchase of immovable property and all that. But a contract entered into by a certified guardian appointed by the court of a minor with the sanction of the court for the sale of the minor's property be enforced. Okay. Again, what did court say? Yes, guardian can enter into a contract provided competence that guardian should be competent enough, and even that particular contract should be for the benefit of the minor. Then only it would be. And again, there is another thing that guardian, not all contracts entered by guardian are valid. If the guardian of minor enters into a contract of immovable property, we cannot bind minor for that unless that contract for immovable property is entered into by a certified guardian. Maybe asked as a question. I mean, they might construct a case law giving that um, contract for immovable property is entered by a guardian, or contract by immovable property is entered by certified guardian appointed by the court. Only in case of certified guardian appointed by the court, contract of immovable property with a minor is enforced when a guardian enters into it. For a sale of minor's property may be enforced by either party to contract. Remember, minor immovable certified guardian can. But guardian appointed by the court for sale of minors, he can enforce. And no specific performance. A minor's agreement being absolutely void, yes, there can be no question on the specific performance. Obviously, already void, we cannot demand any performance. No insolvency. Minor cannot be declared as insolvency as he is incapable. What is insolvent? Declared insolvent means his liabilities are more than his assets, and when he applies for that insolvency, he need not pay any debts. So he cannot be declared as insolvent. He is incapable of contracting debts and dues payable from personal properties, and he is not personal. Partnership. A minor being incompetent to contract to be a partner in a partnership firm. Yes, we already seen this point. He cannot be a partner in a partnership firm, but he can be admitted to the benefits of partnership. Minor can be an agent. A minor can act as an agent, but he will not be liable to his principal. Can act but not liable. A minor can draw, deliver, and endorse negotiable instruments without himself being. Okay, he can draw, deliver. Draw means drawing a check and all that. Delivering and endorse the negotiable instruments that like this checks and all that without himself liable. Okay, he can act as an agent, but he's not liable. Minor cannot bind parent or guardian. The absence of authority, express or okay, an infant is not capable of binding his parent or guardian even for necessary. Okay, just because he goes ahead and enter into a contract for necessaries, usually contract of necessaries are enforceable when entered with a minor, but then he cannot make parent or guardian liable even for necessary. Why did court come up with this? Minors sometimes without, proper knowledge, they might enter into whichever contracts they might take. And for the fault of minor, his parent or guardian cannot always be made liable. Okay, the parents will be held liable only when the child is acting as an agent for parents. But he is acting as an agent for parents. Agent for parents, rather than parents entering into a contract directly, they may this particular children in the minor can enter into a contract as an agent. When this is done, then the parents will be liable. And now we'll take 12 point joint contract by minor and adult. Yeah. Again, we have one case law saying thus versus Ramchand. In this case, there's a joint contract where both minor and adult are a part of that. Even in this case, only that adult will be held liable, not the minor. As we already know, contract with minor is void ab initio. Though there is joint purchase by them, in this case law saying thus versus Ramchand, one of them was minor, it was held that the vendor could enforce the contract against the major purchaser. And now 13 point surety for minor. In contract of guarantee, when an adult stands surety for a minor, then the adult is liable to third party. As there is again, even in the case of surety for a minor is given by an adult. Even in that case, minor is not liable. That adult who has given surety is liable. Minor as a shareholder, as we already know, shareholder is again a contract. Minor cannot enter into a contract, so a minor cannot be a shareholder. If by mistake a member of the company issues shares, then it can resign, that is, cancel the transaction and remove his name from register. But a minor may acting though his lawful guardian become a shareholder by transfer or transmission of fully paid shares to him. Yes, a minor may acting through his lawful guardian become a shareholder. Again, if the contract is with guardian, then he can become shareholder by transfer or transmission of fully paid shares to him. Again, they said fully paid shares because liability is not enforceable against minor, right? So the law is very careful. For fully paid shares, those are already paid, he can become a shareholder. through lawful guardian. Liability for torts. They said tort is a civil wrong. Hmm? Minor is liable in tort unless the tort in reality is a breach of contract. Torts is a civil wrong is what? Okay? But they said if this wrong is a breach of contract, then he is not liable. Because contracts with minor is void ab initio. If this wrong is breach is not performing or not following duties and obligations in that contract, we can't make him enforceable. But they gave an example here. If where a minor borrowed a horse for riding, a minor borrowed horse, he was held liable when he lent the horse to one of his friends. What did a minor do? A minor borrowed a horse. Okay? In this case, usually prima facie, this contract minor is not liable. The case when he would be liable is he gave this horse to his friend. His friend killed that horse. In that case, minor will be held liable because this is a kind of civil wrong. He's done a wrong contract with himself, then no one can ensure. But taking this as advantage, if he's giving horse to his friend is he's kind of behaved negligibly here. So in that case, it is considered as a tort, and when he gave that to friend or any other party, minor will be held liable. Okay, only to the extent of him is not liable. But again, giving the borrowed horse to someone is kind of he's kind of not paying attention to that. So that's the reason he's made held liable. Similarly, a minor was held liable for his failure to retain certain instruments which he had hired and then passed on to him. Similarly, just like this borrowed horse case, if he has any other instrument he has borrowed for himself but then given to someone else, his friend or anyone, he will be held liable. Okay? Again, this is a kind of protection given to other people entering into a contract. Maybe saying that contract is entered with a minor, so though the instrument is damaged and all that, uh, taking advantage of that, they made always it would be a civil wrong. So it said until and unless it is in the purview of the minor, only then we cannot sue him. But if he has borrowed that to other parties, then minor can handle liability. Now we'll see the person of sound mind. We've seen this already. We'll learn it according to section 12. Section 11 talks about minor, and section 12 of the Indian Contract Act says a person is said to be of sound mind for the purpose of contract if at the time when he makes it he is capable of understanding it and forming a rational judgment as to its effect upon his interest. Okay, person is said to be of sound mind for the purposes of making a contract. The law is clear. This is only for the purposes of a contract. Person is said to be sound mind at the time when he is capable of understanding it and of forming a rational judgment. Rational judgment is ideal, normal judgment as to its effect upon his interest. Rational is being able to understand what is right and person who is, yeah, this is very important point. A person who is usually of unsound mind, okay, but occasionally, what did we see in case of unsound mind? Who are they? Lunatic who has attained this unsound mind or any mental illness by an accident, grief, or all that. Is a person right from his birth, someone not do things on his own and all, and drunken and intoxicated by drugs and so these are the people covered under persons of unsound mind. Now we'll see person who is usually of unsound mind but occasionally of sound can make a contract when he is of sound mind. Usually of unsound mind but occasionally of sound mind. So usually he's someone who cannot take rational judgments, decisions on his own and all that. But occasionally if his he is of sound mind, he can make a contract when he is of sound mind. But a person who is usually of sound mind but occasionally of unsound mind may not make a contract when he is of unsound mind. Be clear here. What did law say? He is usually of sound mind. You usually he can take decisions on his own. He can take a rational judgment and all that. But occasionally of unsound mind, you can consider him to be drunken. Usually, when a person is sound mind, when does he become unsound, drunken, or intoxicated, and all that? So usually he's sound, but occasionally he becomes unsound. May not make a contract when he's of unsound mind. Already, this is clear, right? When a person is of unsound mind, we are not allowing him to enter into a contract because he would not be able to think properly and understand the terms of all that. Here, a person who's usually of unsound mind, who would be usually of unsound mind, lunatic or idiot. These people, if they're cured of at some point of time, maybe they're cured of that and they become normal, they can make a contract. But persons who are perfectly all right with a sound mind, but occasionally they drink and get intoxicated and all that, we cannot enter a contract with them because they will not be in the senses and they would not be understanding while entering into a contract. If you clearly see, this is to protect these categories because people may take advantage of this. So, to protect them, law has said usually they will be of sound mind, but occasionally by drinking and intoxicating, they become unsound mind. We cannot enter into a contract when they are in this unsound mind status. Okay, but they are of unsound mind, usually unsound mind. They are, I mean, suffering from some mental illness, but they all this illness got cured. They've become sound mind. Then we can enter into a contract. So see the level of protection, or the level of cautiousness that law is giving not to enter into contract with these when they are not in this. Example: a patient is a lunatic asylum. Lunatic is he's got this mental illness due to accident, grief, that who is at intervals of sound mind. Yes, he got cured of that, or maybe his pattern of illness is like that. He becomes sound mind in between, and then again, due to grief, he becomes of unsound mind. May contract during those intervals. That's perfectly all. But a sane man, a proper rational man, who is delirious from fever, or who is suffering from some fever, or who is so drunk that he cannot understand the terms of a contract or form a rational judgment as to its effects on his interest, cannot contract while such delirious drunkenness, while such illness or drunkenness lasts, he cannot enter into a contract. Okay. Position of unsound mind person making a contract. A contract by a person who is not of sound mind. Void, yes. Again, clearly what we have learned, usually of sound mind, he becomes unsound. We cannot enter into a contract with him. But who is usually of unsound but occasionally of sound, make a contract when he is of sound mind. Contract by disqualified persons, we have learned, besides minors and persons of unsound mind, there are also other persons who are disqualified from contracting, that is partially or wholly, so that the contracts by such persons are void. We have seen who are the persons, foreign sovereigns, that they have got highest designation and highest respect. We cannot sue them. Usually these are ambassadors and all that. They enjoy that privilege. We cannot sue them without taking prior permission of the government. So rather, it's not these people are disqualified to enter into a contract. Anyways, we cannot enforce against them. Alien enemy. We have clearly understood these terms. Alien is citizens other than persons other than Indian citizens. When there is a peace, our with our country, there is no war condition going and all that, we call them alien friends. We can enter into contract with them, but alien enemies are our country is in war with them and not in good terms and all that. No, our country is not at peace with any country, then we call them alien enemies. Alien friends we can enter into a contract. Alien enemies cannot enter contract. Got it? Corporations, convicts, uh, who are serving their imprisonment period and all that, insolvent, who's declared his liabilities are more than assets, and he went to the court and applied that I cannot pay my debts and all that, and court declared. So with these people we cannot enter into a contract. Now we've learned about the capacity of the persons. We've seen three categories. Major one category should be of sound mind and then should not be disqualified persons. We've seen all this. Now we'll learn the other essential free consent detail. Consent is not free. We already knew this. We've learned this many times. We've covered. Not free when it is caused by our mononym, representation, coercion, undue fraud. In these cases, the contract is voidable. That is, one party can go to the court and say, I am cancelling the contract, and court will accept. By mistake, we said it's void. If a contract is entered with a mistake, then it is void. And in mistakes, we have unilateral mistake, which is the mistake is with the nature of contract and to identify the person. In that case, we say that unilateral mistake. Bilateral mistake is subject matter, and possibility of performance is not possible. Possibility of performance, and as to subject matter, there is bilateral is that the mistake is from two parties, both the parties to the contract. Because when there's a possibility of performance, both of them cannot perform that. And even the subject matter is that the crux of the contract is itself not clear. There's a mistake in that, then it's a bilateral. In a unilateral mistake, it is as to identify a person. We'll read it this way. We cannot just identify one party to the contract properly, so that is unilateral mistake. Nature of contract. Now we'll see the definition of consent according to section 30. If you remember, section 11 talked about compete and nature, age and all that. Section 12 talked about unsound. Rather, sound mind explained. Now section 13 is talking about consent. We are learning the essential free consent, right? It says consent according to section 13. Two or more persons are said to consent when they agree upon the same thing, same sense. Okay. Consensus ad idem is the term we've learnt here. Both the parties understood the terms in the same sense. Same thing must be understood as the whole content of the agreement, not only just one or two sentences, but whole content of the agreement should be understood in the same sense. Consequently, when parties to a contract make some fundamental error, after understanding everything, they make some error as to nature of the transaction and all that, the person dealt with or as to the subject matter of the agreement, it cannot be said that they have a same consent. When they are in the same consent, in the same thing is understood in the same sense, there would never be a chance of error. But consequently, when an error is made, that means the party hasn't understood it in this. So when there's a consequently there's an error, you cannot say that we have understood everything in the same sense. Once an error is made, that means you've not agreed. One of the parties is not clear in the same sense. Fine. We'll continue our next session.